Hello, my name is Justin Borg-Barthet. I'm a Professor of Law at the University of Aberdeen and the convener of our Anti-SLAPP Research Hub. I'll be recording a short series of lectures concerning the proposed EU Anti-SLAPP Directive, as well as some EU instruments, some existing EU instruments, as part of the PATFox Anti-SLAPP Curriculum. The agenda for these recordings will cover a number of distinct issues. We'll begin by defining SLAPPs in order to understand what we mean by the term, as well as to consider how different legal definitions in existing laws affect the extent to which anti-SLAPP mechanisms are available to respondents in SLAPP cases. We'll also consider briefly the human rights considerations which come into play when SLAPPs are considered by courts, and we'll then move on in more depth to consider the proposed anti-SLAPP directive and a legislative initiative which was proposed by the European Commission in 2022 and which is currently making its way through the European Union's legislative processes. As we consider the directive, we will need to see the scope of the directive. In other words, what does it cover? What types of actions does it cover? When are anti-SLAPP mechanisms available to a respondent? We'll also need to consider the different definitions which must be satisfied in order for those mechanisms to be available, and then we'll consider the different remedies. In that respect, we'll look at in particular the remedy of early dismissal, but we'll also look at other remedies such as the availability of damages. Finally, in that context, we will look at third country judgments, which is to say judgments of courts outside the European Union, in order to understand how it is proposed that member states' courts can not only enable defendants to repel a SLAPP claim within their own jurisdiction, but also to defend respondents in the European Union from SLAPPs brought in states outside the European Union. The next recording will then consider the private international law issues within the European Union. So we'll look at jurisdictional and choice of law rules, as well as recognition and enforcement of judgments within the European Union, to understand the problems in that space, the opportunities which EU private international law provides to SLAPP claimants, but also to consider what possible defences there may be. And separately, my colleague Dr. Erin Ferguson will provide a recording concerning freedom of information and subject access requests and the way in which these can be used to help a SLAPP respondent to equip themselves against vexatious litigation. In this short recording, however, all I will do is provide a little bit of background about SLAPPs. And the story in the European Union begins with the tragic assassination of Daphne Caruana Galizia, a woman who was described as a one-woman WikiLeaks in Malta in view of her investigative journalism. The assassination of Daphne Caruana Galizia prompted non-governmental organisations and members of the European Parliament to look at what it was in the environment for freedom of expression in Malta in 2017 which enabled her assassination. And what they found, to their horror, was that Daphne had been subjected to dozens of lawsuits, many of which were manifestly unfounded. And the purpose, of course, of these lawsuits was to suppress her investigative journalism, to stop her from publishing her work and therefore to stop the public from being informed about what she had discovered. Essentially then, Daphne was subject to many SLAPPs, many strategic lawsuits against public participation. So what then do we mean by SLAPPs? As I said earlier, there are many different definitions of SLAPPs which we'll look at in more depth in in another recording. For the moment, however, we need to have a working definition, and a good working definition is available in the Coalition Against SLAPPs in Europe's model law. What that provides is that SLAPPs are claims which arise from a defendant's public participation on matters of public interest. So it doesn't matter what type of public participation is concerned. We're not talking only about journalism. This includes, for example, environmental activism. But of course, the claims, in order to properly be defined as strategic lawsuits against public participation, must either lack legal merits, which is to say they must be unfounded or manifestly unfounded, or else they might be characterized by different elements of abuse, such as, for example, misuse of appeals procedures or excessive claims for damages in order to scare the respondent. Essentially then, they are claims which use the judicial process not to exact a legal right, but in order to vex the respondent, to cause harassment to the respondent, and therefore to force them into doing something they would not otherwise do, which is to say, to stop the acts of public participation in the public interest. As I said, we'll look at definitions more closely in other recordings. At this stage, however, it's worth having this working definition, a quite broad working definition, to understand what is at stake. Matters of public interest, public participation in the public interest being suppressed through the misuse of the legal process. You might ask, of course, why this is a problem. Well, ultimately, it is a problem because legal proceedings can be particularly expensive. So what SLAPPs do, where we have unfounded claims or abusive claims brought to court, what this does is it imposes a financial cost on the respondent. Now, some people simply can't afford to defend themselves in court. They simply can't match the legal arms which the claimant has, and therefore they might simply give up. But of course, even if they don't give up, even if they accept a demand to stop doing what it is they're doing, to stop publicizing what it is they are publicizing, there is also a psychological cost. Legal proceedings are stressful. They're stressful not only because they're expensive or because the claimant might have made a particularly exaggerated claim, but they are stressful simply as a function of an unfamiliar and often scary legal judicial process. And ultimately then, even if somebody accepts the financial cost of legal proceedings and accepts the psychological cost of legal proceedings and carries on and defends themselves, there is also an opportunity cost. An opportunity cost, which is to say that a journalist or others acting in the public interest will not be focusing on their work, but will be spending time and money investing themselves and their financial resources in defending themselves in court against a claim which is designed to abuse the judicial process rather than to enforce a legitimate right. And of course, recall that we're not talking here about legitimate claims. You are talking about claims which are designed to be abusive. It follows then that SLAPPs are a significant problem because they misuse a public service, the judiciary, in order to vex a respondent, in order to abuse a defendant rather than to exact a legitimate claim. Now that all so far has been quite conceptual. We haven't really seen what this does in practice, what it does to the news, what it does to activism. Well, the case you can see on the screen now is the Pilatus Bank case, which came to light in 2017, just days after Daphne Caruana Galizia was assassinated in Malta. It became clear that not only had Malta's premier journalist been assassinated, but at the same time a separate attack was happening on the Maltese press, and through the threat of litigation in the United States, in the United Kingdom, and frankly anywhere, because the claims were drafted in such broad terms that respondents couldn't know where they were going to be sued, serious stories, serious and verifiable stories about money laundering involving politically exposed persons in Azerbaijan and in Malta, involving a money laundering network which extended well beyond Europe's smallest, the European Union's smallest member state, and which extended to several other jurisdictions and indeed threatened the United Kingdom and provided a route for money laundering through Angola, through Portugal, through several jurisdictions throughout the world. Those stories all started to be deleted. The threat of a slap resulted in the public record being changed. So you have on the left of the screen a selection of stories showing serious money laundering at a bank situated in Malta, serious money laundering involving Azerbaijani politicians, and a major energy project which was situated in Malta but also was intended to be replicated elsewhere. And after Maltese newspapers were threatened by Pilatus Bank, there weren't court proceedings, it was just a threat. What happened was these stories started to be deleted. So you see error 404 on the Malta Independent. Malta Today, another Maltese newspaper, did the same. Several other online websites in Malta did the same. The Times of Malta replaced this story about serious failures with a story saying that the money laundering concerns no longer subsisted. So the public record being changed, the truth becoming what claimants in this case, claimants who clearly did not really have a leg to stand on legally, wanted the truth to be. So slaps are, of course, a serious problem. And in the rest of these recordings, I will seek to explain a number of evolving mechanisms in the European Union, in European Union law, which seek to address that particular threat. Because, of course, this case of Pilatus Bank, as you will know, is not an isolated example. There are examples of stories being redacted and deleted, and publications not coming forward throughout Europe, throughout the world. So I've used one example on this slide, but of course you will be aware in your own practice, in your own work, that this is a problem which exists throughout Europe, and therefore throughout Europe there is a threat to the public's right to know, and of course there is a threat that malfeasance continues to be hidden from the general public. So I will explain a few mechanisms in subsequent recordings. Thank you.